Now, I think that the reasoning of the US Supreme Court in this case raises some questions. The first is fairly straightforward. Is it really proper to treat works in the public domain and works within the term of copyright protection in the same way? The second issue is a little bit more complicated and has to go back to my comments regarding who would be the proper moral rights claimant in this situation. Moral rights theory generally requires that the original author of the work be the claimant, and that original author must be a human person. So a corporation, normally speaking, can almost never make a moral rights claim. This rule does have some exceptions, but they occur in very specific cultural and legal circumstances. For example, Japan actually does have a provision that allows corporations to make a moral rights claim. But I think that that has to be understood in the context of a very different corporate culture from what we know in North America, or Europe for that matter. So here in the Daystar case, we have these, once again, very awkward facts. It's a claim by a corporation for moral rights, and in fact, the corporation that's making the claim is not even the corporation that's responsible for the original work. So very unattractive facts on which to test a moral rights principle in the United States. And I think that the justice's intuition in this case that this is the wrong claimant is probably a correct intuition. But it doesn't necessarily mean that there is no possible rightful claimant, that no one is in a position to be able to make a successful moral rights claim in situations like these. And finally, it's important to keep an eye on the novelty of the claim in question. So again, I think the Supreme Court has the right idea here when it seeks to determine the appropriateness of applying a statutory provision on false advertising to protect the moral right of attribution in a work. But this brings us full circle. What is the alternative under US law? And this really highlights the key difference between the era of the Shostakovich case and the present. When Shostakovich came around, the United States did not have any obligations in relation to moral rights under international copyright law. Now it does. So international obligations are an important reason why the US legal community needs to be interested in moral rights. I will go on to say, it's not just a question of fulfilling international obligations under US law. There's also another question here, which goes back to the title of my book, Moral Rights and New Technology. So there's an issue here about the United States being the leading country in the world when it comes to the digital revolution and digital technology. We have seen the impact of technology on economic copyright through phenomena such as music downloading, film and software piracy, and so on and so forth. But the moral rights issues involved in new technological phenomena have not really been discussed at all, very minimally. In fact, I think what we are going to find is that moral rights are very important in a digital environment for social reasons. So what happens when a work is digitized? Well, we can intervene in that work. In fact, anyone can intervene in it, usually without our knowledge. We can remove things, we can change words, we can insert or remove images, we can change, remove, or add the name of an author. There's so much that we can do to intervene in works. And when these things happen on a fairly large scale, the impact on society could be tremendous. It could cause the corruption of information and knowledge, potentially damage to the integrity of our cultural heritage, the destruction of historical truth. These are likely to become major social issues in a digital environment, even if we haven't yet recognized them or confronted them fully. And moral rights of authors are an important legal instrument for the prevention of some of these problems. Now, given the need for improved recognition of moral rights in the United States, one of the important sources of knowledge available to the US legal community is to consider some of the ways in which moral rights have migrated to different countries and how the doctrine has been received by them. As well, how the doctrine itself is able to adapt to different cultural environments. So I'd like to go on now to consider our international benchmark before we take off on our miniature global odyssey and consider what the Berne Convention actually tells us about the international baseline requirements in the area of moral rights. Now, the Berne Convention is a classic formulation on moral rights. And when we deal with moral rights in different countries, we don't invoke Berne directly, usually, but it does provide us with guidelines about what legislation on moral rights is supposed to do in the member countries of the Berne Union. And another important point to note, because it wasn't always the case, is that now practically every country in the world is a member of the Berne Convention, the Berne Union. Okay, there was a time when not only the United States, but most of the Eastern Bloc countries were not members. Developing countries had questions about their involvement and so on and so forth. This period of time in the history of Berne is different. It's a time when Berne has really become very well established in the international community. This is more text than I normally like to put on a PowerPoint, but I'll walk you through it very quickly because there's really no other way to communicate what's in the convention, masterful piece of drafting as it is. So 4 points to note about the Berne Convention provision on moral rights, which I've underlined. The first, this provision on the independence of authors' economic and moral rights. That's a key provision because what it means is that even after you have physically parted with a work, or after you've parted with the economic copyright in a work, a moral right continues to persist, and you as the creator continue to hold that right. So it creates an interesting legal anomaly between ownership and the control of a moral right. That's what independence means. Secondly, notice that the right of authorship is identified, so there is a right of attribution that is identified by Berne. We also have a right of integrity, a right to protect the work, to object, as they say, to any distortion, mutilation, or other modification of or other derogatory action in relation to the work. And fourth, notice the clause at the very end of that provision. You can only object to these acts if they would be prejudicial to your honor or reputation. So this is a very important limitation. It means that you as the author bear the burden of proof in a claim for the protection of your moral rights. And it might be difficult to satisfy that particular burden of proof because you need to know what kind of proof you have to offer and how persuasive it's going to be. So, for example, in Canada, the acceptance of expert opinion by the courts is an important principle, firmly ensconced as a result of the one successful litigation on moral rights that we've had in the past 80 years. Economic damage is another factor that is widely accepted in common law countries. I should also mention that this provision may mean that destruction of a work is not a violation of the right of integrity. Although that argument might seem counterintuitive at first glance, the reason is that destruction is said not to affect the reputation of the author. It destroys the work. There is no damaged work there to affect the author's reputation negatively. And I'll come back to that when I talk about the Indian case, because Indian judges are very hostile to that particular view of the right of integrity. They think that destruction should be covered by that right. Second part of the Berne Convention, sorry, it goes on. I did leave out the third part. But this part is important because it has to do with the duration of rights. So what it tells us is that the rights last at least as long as the economic rights, so at least until the expiry of the economic rights. And there is a provision here which says that if your country doesn't have moral rights legislation when you join Berne, you can stop the protection of some of those rights early. That provision, introduced in 1967, I believe, actually was specifically intended to accommodate common law countries, and the claim that most of our countries make that our tort law protections effectively cover the moral rights interests of authors. I should mention that because the Berne Convention only provides a minimum standard of protection, it's possible to have a longer duration of protection for moral rights, and many countries do. France, for example, protects moral rights forever. And that might seem to be something of academic interest, but actually it has very practical implications. The latest case on moral rights from France from 2007 was actually brought by the great-great-grandson of Victor Hugo. And the case had to do with someone who had written a sequel to Les Miserables, essentially reviving a character who had plunged off a bridge at the end of the original novel and proceeding to create a new story around those characters. It's an extremely interesting case because at first hearing, the French court upheld the claim of the great-great-grandson, all the more so because Victor Hugo, during his own lifetime, had asserted his dislike of the idea of any sequels to his work. He said the work is complete, it's a complete statement, nothing should follow after. And when the French court agreed with that perspective, it was taking a very traditional French approach to moral rights, where the acceptance of the author's point of view, a subjective approach, is favored. Now, interestingly, the case went on to appeal, and that ruling was actually overturned by the Cour de Cassation of Paris. And that court came up with a very common law style argument. It said, well, sure, Victor Hugo objected and this and that and the other thing, but actually, if we're going to allow this claim to succeed, we are seriously limiting the creativity of that new author who has made a work of value out of those existing characters and has a new copyright in his own right in that new work. And so the ruling was overturned on those grounds. Some French commentators support it. Some French commentators are strongly critical because it does represent a break with tradition. So that's what can happen when the moral rights last forever. In India as well, from 1957, when India first got its Copyright Act, right up until 1994, you had perpetual protection for moral rights. It changed in 1994 because the government became afraid that it would then be responsible for recognizing moral rights in the works of authors who were long dead. And when we get to India, you'll see exactly how that played out in practice. If I click on this, will this get me to the internet? Okay, well, let's try and see. So I thought we could start our global survey with the UK, which is sort of the mother of all common law systems. And
burning, 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 burning. Do keep hearing a fire engine. Ting-a-ling-a-ling while alarm bell ring, but you can't go out the fire.
This is what the case was about.
Burning, burning, burning. Do keep hearing a fire engine. Ting-a-ling-a-ling, alarm bell ring. You can't go out the fire.
I don't know if you can tell, but the speaker is actually inventing some words to make the rhythm of the speech go along. That was actually a key material fact in the case. I didn't plan to make you listen to the whole thing. There we go. Okay. So, as you can see, it was a case about, I guess you could call it rap music or hip-hop. So we have the hip moral rights in the UK. It's a song called Burnin', as you probably gathered. And it was composed by a person named Andrew Alsey, who sold that composition to a group called Confetti Records. Now, Confetti was a small label specializing in something called UK garage or speed garage music. You probably know more about this than I do. But what Confetti did was it hired a group called the Ant Hill Mob to record it. And this was what's known as a concept group in the music business. So it had no permanent members. It was just session musicians who gathered together, formed this group, and made the recording. Song turned out to be successful and actually rose to the #1 spot on the UK Garage Top 10 list. When that happened, it was noticed by the Heartless Crew, a UK